All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date scheduled for oral argument in our cause number CV240030, Chayce Concrete LLC versus Path Construction Southwest. These proceedings are being audio and video recorded as well as live streamed, so I ask you introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. Appellant's counsel is required to keep track if you want any portion of that time for rebuttal. Also, we have read the briefs. We have discussed this case in conference this morning. We are familiar with the facts of this case. Bear that in mind during your presentation. At this point, counsel, are you ready? Please proceed.
Can I tell about Kent?
Oh, and as you all notice, we have an empty chair. I forgot, Judge Katani wasn't here. He is ill and will be watching on the live stream. He'll watch the video, but we didn't want him to breathe on us or you. So for our own safety, we are letting him stay home.
Thank you.
Good morning, Your Honors. My name is Brendan Melander on behalf of Appellants Path Construction Southwest and Liberty Mutual Insurance Company. May it please the Court. Path Construction lawfully obtained a binding arbitration award, and Arizona has a strong public policy favoring arbitration and upholding those awards. In furtherance of this policy, there is an abundance of case law that holds arbitration awards should only be disturbed on narrow statutorily enumerated grounds. Despite this, when Path Construction sought to confirm its award, the Superior Court vacated Path Construction's award and misapplied the RUAA, which is the Revised Uniform Arbitration Act. What's worse, in doing so, the Superior Court almost entirely copied and pasted Chayce's motion to vacate in its order. This resulted in the Superior Court substituting the arbitrator's findings of fact and law for its own, including by relying on facts directly conflicting or unsupported by anything in the record. Path Construction respectfully requests that this court reverse the Superior Court's order, confirm Path Construction's binding arbitration award, grant Path Construction its reasonable attorney's fees, and remand this matter to the Superior Court, requiring it to comply with the RUAA. I want to make a couple of points. This court should apply a de novo standard of review. Arizona courts have yet to establish a standard of review for reviewing vacation of a binding arbitration award. However, while confirmation of awards are reviewed for an abuse of discretion, interpretation of statutes are a legal question which is reviewed de novo. Since the Superior Court and courts may only utilize a statute, the RUAA, to vacate an arbitration award, it is necessarily a question of law and de novo standards should apply. Additionally, for persuasive value under the FAA, which is the Federal Arbitration Act, the Ninth Circuit utilizes a de novo standard of review for vacatur of an award. The same should apply here.
Counsel, do we need to, in your opinion, get to a de novo kind of evaluation, or do you think abuse of discretion is what occurred here?
Thank you, Your Honor. I was actually going to make that point that in either standard review, abuse of discretion, or under a de novo standard review, Path Construction's claim should prevail, and it should be reversed.
And what is your best argument for sustaining that?
For sustaining
or overturning the lower court, for sustaining the arbitration award, I guess is what I'm saying.
Your Honor, I think the fundamental reason being that the arbitrator made findings of fact and law that were overturned by the Superior Court when they should not have been. And I can explain my basis for that as the argument progresses.
Before you get to that, I do have a quick question. You state in your briefing that there was that Chayce should have done a public records request.
Yes, Your Honor.
Was there an obligation for you to disclose the information?
Your Honor, pursuant to the responses to the discovery which they proffered, we specifically informed them which documents we were providing and which documents we were withholding. In those would have been the pay applications. I think that the point making there is that the arbitrator considered those points, and along those lines, the arbitrator, part of the rationale which the arbitrator Friedlander put in his 16-page ruling, which is rather detailed and conclusive, was that he could have made a public records request, and therefore these documents could have been discovered, so it wasn't as if they were withheld and he was prejudiced by that withholding.
But we don't require somebody to go out and do a public records request, do we, if there's an obligation on the party to disclose the information?
No, Your Honor, we would not require it, but again, Path Construction made specific objections and told what documents they were withholding. And this goes to the point that Chayce should have brought these issues up or had met and conferred with us or with Chayce had they had these ongoing issues which could have been resolved well before the arbitration, which goes to why the arbitrator ultimately made, in his discretion, his findings of fact and law and made the decision not to postpone the hearing.
Well, I don't think you've answered my question. Was there an obligation upon your client to disclose the information? Let's start really basic. Was there an obligation?
So, Your Honor, and I apologize for not...
No. I just want to make sure I'm clear. If there was an obligation from your client to provide that information.
Under the AAA rules, and again, I apologize, I don't have the specific framing of the language in front of me, but under the AAA rules, you're only required to disclose the documents in which you intend to rely upon. There is a mechanism for discovery requests, which was in the submission agreement and by the parties' agreement. On those, what would be, I believe, again, paraphrasing here, what would be reasonable and relevant. In the discovery response, which is at our issue here, my client specifically objected on the basis of reasonableness and relevance that those pay applications did not be produced. So to answer your question, there was no obligation under the rules to disclose it. There was an obligation to respond to the discovery request, which they did.
Well, I thought the arbitrator found that the information was relevant. I mean, he used it against your client when it came to making the award, right?
Your Honor, I believe the language that he used, quote, was potentially relevant. And so, again...
Are we splitting those the hairs that fine if there is an obligation? There's a potential obligation, a maybe obligation?
Your Honor, I guess the point is that...
Is there a little bit pregnant? Either you're pregnant or you're not, right? So is there an obligation or is there not an obligation?
Your Honor, I think my client had an obligation to respond to the discovery request. I don't think there was an obligation to provide these documents because they were not relevant to this case. And Arbitrator Friedlander specifically indicated inside of his ruling that these pay applications would not have changed his findings at all.
But he used them against your client. He used the lack of disclosure against your client.
Yes, Your Honor. He used...
To me, it sounds like that's an obligation.
I think what the point that Arbitrator Friedlander made was that Path Construction can't try to rely on something that it didn't disclose in improving his damages claims. And so when you said he used it against his client, what he did is he indicated because the evidence wasn't there, Path Construction didn't meet the burden to prove its claims.
Okay.
I want to make one final point on the de novo standard review. From a public policy perspective, courts are encouraged to liberally confirm arbitration awards. Vacating awards is only for extreme circumstances. It makes sense that there would be different standards of review for a confirmation of an award and a vacation of an award. And like I mentioned earlier, under either standard of review, Path Construction believes its claim should prevail. We got into a lot of different points, so I will try to just highlight a couple more points here and then reserve the remainder of my time for rebuttal. I mentioned it in my opening, but the Superior Court order is fundamentally flawed. If you review the order in Chayce's motion to vacate, almost the entirety of the order is directly copied and pasted from Chayce's motion to vacate. While
That in and of itself does not invalidate what the trial court said or can put in his order just because he parroted somebody else's argument. He agreed with them.
you are right, Your Honor, but the issue is that Chayce's motion to vacate made findings of fact and law which were completely unsupported by the record and opposite of what arbitrator Friedlander made.
Point out those facts.
There's a couple of them, one being that he requested a postponement. There's no evidence in the record at all that he requested a postponement.
I thought there were some statements made to the trial court at the time of the hearing that he had requested.
So Chayce's counsel indicated after the fact, during oral argument, that he made this oral request for a postponement, but it's completely unsupported by the record in any indication. So there are at least, and sorry for not naming them, but there are about 4 or 5 different briefs that were filed during this time. Not one mention from that evidence supports a finding that a postponement was requested either orally or written. And I believe, again, Chayce has admitted that they didn't make a written request, which was required under the AAA rules. So that's just one. There's the many inaccuracies within which I pointed out to in my brief. But the major one is that there was even a request for a postponement in the first place. Even if Chayce did request a postponement, Chayce did not provide the sufficient cause for postponement required under the RUAA. There are limited cases in Arizona which discuss the postponement's insufficient cause and prejudice standard required. However, there is a synopsis of case law which was provided in Path Construction's brief, which did their best to take analogous statutes to the RUAA across the country, as well as use the FAA, which is very similar, to draw some parallels and find what should be the applicable case law. The first being is that there's reasonable basis for the arbitrator's decision. The arbitrator had plenty of reasonable basis for his decision. He came to a 16-page order, which I discussed before. Arbitrator Friedlander, as we've talked about here, judges, he discussed the production issue in detail when coming to his determinations. On top of that, Chayce waived any request for a postponement under the AAAs, like I mentioned. There was no request, I believe.
Counsel, if I may, I'm sorry to interrupt. I mean, I'm not sorry, but so let's assume for the sake of this is a hypothetical. So let's assume that they actually did make a formal request for a postponement and the arbitrator denied it. Is that per se reversible at that point in time? I mean, can any party in an arbitration simply say, I need a postponement, and the arbitrator has to grant it?
No, Your Honor. The statute says there must be sufficient cause and there must be prejudice.
And do we review, whether we're reviewing it or the Superior Court is reviewing the arbitrator's decision to grant or deny a postponement, do we review that for an abuse of discretion?
In terms of what the Superior Court's review is, they're constrained to the findings of fact and law which the arbitrator made because, from a public policy rationale or from the rationale expressed in the cases that discuss this issue, is the arbitrator isn't the person that is in the best position to make this decision. So what the standard that comes out here is whether or not the arbitrator had a reasonable basis. And it's a highly deferential standard.
Well, it sounds to me that that's an abuse of discretion. The Superior Court would be reviewing that determination for an abuse of discretion.
The Superior Court should review the arbitrator's decision for an abuse of discretion. This court here should review on a de novo standard review.
Well, then we would be reviewing it for an abuse of discretion.
You're reviewing a different, so for example.
I think he's confining, you're talking just about the postponement.
Just about the postponement. My hypothetical started out,
yes.
There was a request for a postponement, and the arbitrator rules on it. And now we're talking about whether he granted or, well, it would be denied. If he denied the postponement, the Superior Court and this court would look at the denial for an abuse of discretion. The arbitrator would have had to abuse his or her discretion.
I think that's correct, Your Honor. I would say the denial itself should be an abuse of discretion, but I just want to clarify the nuance that a de novo should be reviewing the Superior Court's decision. I know it's a slight distinction.
I'm not sure how we get there. If we're reviewing it de novo, we would have to look at the arbitrator's decision to see whether or not he or she abused their discretion.
Your Honor, I think it's a little bit of a distinction because from a de novo, a review of the Superior Court's decision, not the arbitrator's decision, I guess is the nuance there. Okay.
I think we're talking ships passing in the.
Yeah, and I apologize.
No, it's
I'm
okay.
trying to answer your question, Judge. I do apologize.
So let's say hypothetically that we begin an arbitration, there's an argument made, there are documents that were not disclosed that would support that argument, and we object and then move for a continuance to get those documents, right?
Yes.
Would that have been appropriate here? Is that what happened here?
I think it's Your Honor, thank you. I think it's completely appropriate to request a continuance or a postponement at the appropriate time. I think the issue here is that the phantom request for a postponement happened at the arbitration itself, after everybody had already began, when there would be prejudice to the to Chayce or to apologize.
So are you saying that there was no surprise in the lack of disclosure and the arguments made at the arbitration? Because I think that's what your opponent is arguing, that they weren't aware of some of the documents being relevant.
No, Your Honor, there was no surprise. I mean, these documents, first of all, the discovery requests were submitted, I believe, in November. The arbitration hearing wasn't until the following February. In the discovery request, Path Construction affirmatively said what it was disclosing and what it wasn't disclosing. A review of those documents would have they could have easily determined what was in there, what wasn't in there. There was no surprise here. They could have taken affirmative steps to meet their discovery obligations, and they didn't do that. And I guess from an analogous situation, courts in this circumstance, if you wait past the discovery period and you wait until the day of trial, a court would do the exact same thing and say, hey, it's too late. Your postponement's denied. We're moving forward with trial. It's the same exact situation which Arbitrator Friedlander made here. And again, I want to stress is that Arbitrator Friedlander came to that conclusion of findings of fact and law, which should not have been disturbed by the Superior Court in the first place. I noticed that I have 3 minutes and 44 seconds left. I was trying to address all of your questions. Given the reasons set forth today, this court should reverse the Superior Court's order, confirm Path Construction's arbitration award, grant Path Construction their reasonable attorney's fees, and remand this matter to the Superior Court, requiring it to comply with the RUAA. Thank you for your time. I really do appreciate it. Judge Catani, I hope you feel better. I will reserve the remainder of my time for rebuttal.
Thank you.
Good morning. May it please the court, Bobby Thrasher and Chris Robbins on behalf of Chayce Concrete. I think I'd like to begin by clearing up a few things. The first is there's a strong public policy for full disclosure. I think that we can all agree, hopefully, that cases should be litigated on their merits. And unfortunately, this case wasn't. When the trial court was faced with those facts, it made a decision to vacate the arbitration award. That is...
Well, except you have a problem because the court could only vacate the award under certain circumstances under the statute, right?
Yes.
Okay. So let's start talking about, first of all, there was disclosure, and that disclosure happened approximately 4 months before the arbitration?
It did.
And when did you file a pre-arbitration statement with the arbiter?
Judge, it was in February before the hearing.
Okay. How many days before the hearing?
I believe it was 5 days before the hearing, but I don't want to avow that for certain.
I had it listed here in my notes as 4 days before the hearing, but, you know. Okay. In the pre-arbitration statement,
did you make any reference to the lack of disclosure, as in, I need a continuance?
Thank you
It really
for,
calls for a yes or no answer.
I did, but
Where is it in that statement? Because I'd like to go read it.
where is it in the pre-hearing statement?
Yeah, where did you say in the pre-hearing statement, I need a continuance?
Oh, I didn't say I needed a continuance. What I did say was I was concerned with respect to some documents that were missing, but specifically, Your Honor, we were referring to documents related to scheduling, calendaring, critical path information, stuff that was unrelated to what we learned on the first day of trial. And I think that's the issue in this case. We're conflating two different things. On the first day of trial, and I was the trial counsel, so I'm able to refer to all these things. We appeared at the arbitration hearing, and
Isn't 4 days before the arbitration a little late, or 5 days before to be asking for a continuance?
I didn't ask for a continuance, Judge. I didn't think we needed one. What happened was, at the arbitration hearing, Mr. Lynch, it was the first and only witness that
I thought one of the bases to set this aside was the lack of a continuance.
It is. Once we learned of the lack of disclosure during the testimony of Mr. Lynch, who testified.
Okay, did you, so we're clear, this disclosure was 4 months before the arbitration. Nothing was filed with the arbiter until what, 5 days before the arbitration hearing?
Judge, we didn't learn of the existence of these documents until Mr. Lynch testified that there were material information related to pay apps, non-performance from my client. It wasn't until he testified that there was any of that. When I got the discovery and I looked at all of the information that was produced, I felt very confident that, well, this helps my case. You didn't show these things. You're required to show these things. The lack or the omission of not doing these things is a material breach of the contract. That's how the case was framed. That was consistent with what my client was telling me. We then get to the hearing, and Mr. Lynch says, oh, we did that. That exists. And they're trying to get this information and evidence, and my reaction was, whoa, this is improper. We requested these documents. They didn't produce them, and this is prejudice. And I think the arbitrator recognized that.
And accounted for it in the award, did he not?
Well, I think he certainly referred to it. I don't think he accounted for it properly in the award. I think that is what the trial court found, that
But that goes to the merits. That's not going to the merits takes you outside of the statute. The statute basis to take away, to vacate an award or not affirm an award has to be based on certain statutory requirements.
I agree, Judge.
Okay, so if we're saying, oh, he didn't account for it enough, well, then that's not in the statute, is it?
Well, I don't know that he accounted for.
Can you give me a statutory site where you think it is accounted for in the statute?
I think that the statute that is applicable in this case, Your Honor, is 3023 A1 and A3. And I think where an award is procured by undue means, that it is incumbent, and the statute says that the court shall vacate an arbitration award. I think that is an abuse of discretion. I think the trial judge recognized this and properly vacated the award. I think the second statute that is...
Were they really trying to hide the ball when they specifically say this is what we're producing and we are not producing this?
They're absolutely trying to hide the ball. Absolutely. There's no doubt in my mind, and I think the evidence is clear, that the most relevant information in the case, i.e. the pay apps and the issues related to my client's non-performance, which we specifically requested, was not disclosed. So I guess as a trial attorney, I'm put in the position where if there is now an objection to any request for production, is it incumbent upon me to, in every case, file a motion to compel? I don't think that's our law, and or rules, and I don't think that's the public policy that this court should want want to further, Your Honor. I think
there's a meet and confer requirement prior to filing a motion to compel. Did you ever try and meet and confer to get documents that you believed to be relevant before the arbitration?
we did, Judge, and there was a
Where is
meet.
that in the record?
The meet and confer, I don't know that it's in the record because we didn't have a transcript. The meet and confer with respect.
Well, I'm sure you put it in your post-hearing motion, right?
In my post-hearing motion. And maybe I'm understanding what you're speaking with respect to the meet and confer. There were several meetings that counsel had with respect to getting ready for the arbitration with the arbitrator. It wasn't until, again, it was the first day of the hearing where Mr. Lynch testified that all of these documents existed. I guess at that point,
So I think I need you to be more specific.
okay,
Because they have objected to production of documents. And you're saying these documents existed and you didn't know they existed. What document specifically are you speaking of? And what was the relevant objection to the production of those documents from PATH?
okay. Excellent question, Your Honor. And I have the objections here. Here's what it says. And there are several what this is specific to. It says, see general objection, and this is with the response to request number 3. See response, general objection number 10, subject to and without waiving objection, PATH will produce non-privileged, non-protected documents within its possession, custody, and control responsive to this request. Again, request number 5.
Requesting?
I'm sorry?
What is number 3 requesting? What document?
Please produce all communications, correspondence, documents relating to work completed by Chayce and/or completed by Chayce for the Pima Dynamite pursuant to the parties' agreement, which PATH claims that PATH Dynamite suffered delay and/or PATH incurred expense, and then it defines communications, which specifically during the cross-examination of Mr. Lynch, he testified that those documents existed. My argument, and I think appropriately so, was, well, you've never put my client on notice of any of these things. There's nothing in the record. You said that you produced them because, be clear, when you look at this objection, it's a qualified objection. What they're saying is they're producing documents subject to objection. They're also saying that they're producing all non-privileged documents, and they're specifically saying work pertaining to Chayce. This work pertained to Chayce. It was material. It was relevant. This idea that, oh, well, we only have to produce information, documents related to what we want to use, well, that's not true, and that is in the AAA rules, and it specifically says they have to produce relevant and material issues that are related to the outcome of disputed issues. This was directly related to the disputed issues.
So, communication about work completed by your client.
Yes.
What you're saying is they did not produce those documents. How were you not aware that they did not produce those documents? I mean, what specifically were you looking for that you didn't get that you're saying that they referenced on the stand? Here's what I'm struggling with.
Yes.
I'm going to object. I'm not going to give you what you're asking for. In civil litigation, happens all the time.
Understood.
What do?
Understood.
We follow up, and we call them, and we say, give me this. And if they won't, you can call the arbiter and say, these things I need to present my case. Can you help me in getting them to give them to me? None of that happened.
Well, let me explain what happened in this case, because I think it's a very discrete factual issue. The first issue is, we're talking about 3 pay applications that my client submitted, and there was a lot of dialogue going back and forth between Chayce and PATH. And essentially, it was, when are we going to get paid? When are we going to get paid? And it's crickets. There's nothing coming from that. And if you look at the statute under, I think it's 221H, just for a record, Judge, it is 34 221 subsection H, there's an obligation. You may not have to submit the applications to the owner, in this case Scottsdale, but you can't just sit on them and provide no information whatsoever. So when I'm looking at the case and I'm seeing that the request for production is completely void of any information specifically related to the pay apps, I'm like, this is clear. This is consistent with my client's position. They did nothing. They sat on them, and they did not act in good faith, and they materially breached the contract. This is consistent with my understanding of the facts of the case. I get there at the arbitration on the first day, and we learned then from Mr. Lynch that, well, maybe this isn't the case. Oh, and wait, we have documents. Well, if you have the documents, why weren't they produced? If you look at the discovery request...
Did they use those documents at the arbitration?
The arbitrator, they didn't have them at the arbitration. They said they didn't they said they existed, but they didn't produce them at the arbitration either. Mr. Lynch testified to
And
them.
the arbitrator held that against them, right?
I think the arbitrator recognized that and made reference to them in his ruling. I don't think he held them against them.
Well, he discounted what they were asking.
He discounted some of the liquidated damages as a result of the fact that they sued several other subcontractors, which they didn't produce that information as well. But he didn't take into effect that they didn't disclose the pay app information, which was, there wouldn't have been a more critical piece of evidence in this case.
A pay application.
The pay application and communications with the city of Scottsdale with respect to...
But the pay application would have come from your client.
Pay application, and I misspoke. The pay application goes from my client to PATH, and then PATH is supposed to take the pay application and submit it to the city of Scottsdale. If there are non-performance issues, if there are other concerns, there needs to be communication between PATH and Chayce, which there wasn't. When these documents weren't produced, I think I have a right to rely on they don't exist, which is consistent with my client's position on the case and the fact that they didn't do anything. And I think that's likely, because he testified that they didn't produce the documents, and at this point, I think we were left with clear misconduct, and the issue is, well, it wasn't in writing. Well, this occurred on the first day of trial, and if you're either a trial attorney or a trial judge, we've all seen these issues, and they arise. And when they arise, the remedy is, how do we eliminate the prejudice in the least onerous means? And
If I'm a trial judge in the middle of a civil trial, and this happens and there's a discovery dispute, I turn to the jury and I say, you can hold it against the client. I don't discharge the jury and continue the trial, do I?
I asked to hold it against him, and it was denied. I thought that an evidentiary inference was appropriate, and that was denied as well.
But that doesn't get you a vacatur because under the vacatur under 3023A1, it requires proof of intentional misconduct.
What I think it gets you is under A3, where an arbitrator refused to postpone a hearing on a showing of sufficient cause for postponement. I think...
Okay, but that requires a written application, and you didn't make a written application before the arbitration. You didn't make a written application in your pre-arbitration statement, nor did you make a postponement request in your post-arbitration hearing, did you?
I think at that point, Judge, the arbitrator had ruled on the issue. I think any written motion would be moot. I don't think that it was going to be...
Well, you could have objected and said, I need more time, because now I know they exist. I have to get these documents.
I did object and said I needed more time during the arbitration hearing.
Okay, we don't have that in our record, do we?
There was no transcript. We did not record it.
Okay, so we don't have it. If it doesn't exist in our record, we don't have it.
Okay.
So there is no written objection. There is no, beforehand, 4 months beforehand, before the in your pre-arbitration statement, nor in your post-trial, in your post-arbitration.
I guess where I would disagree with Your Honor would be, if you're unaware of the lack of production, that the documents exist, how are you supposed to object to it 4 months before? I was completely unaware that these documents existed until Mr. Lynch testified.
So let me ask you real quick. So you're talking about a submission from Lynch to the city of Scottsdale.
Correct.
Isn't your client entitled to get those from the city of Scottsdale?
There is a mechanism by statute for my client to get those. I would say that it would be unusual under the circumstances. I think you should be able to rely on, and there is a requirement of good faith and fair dealing in every contract where there's some communication. And the testimony was, and the evidence and the exhibits showed that there was multiple instances where my client was requesting status and it was crickets. Back to Your Honor's position with respect to...
I'm just asking questions. I have a stated position.
And I misspoke. I'm sorry. But I think, just for purposes of argument, because I believe that under A3, we're entitled to a continuance, I'm obviously. But under A1...
you think there was an intentional misconduct?
Absolutely. Undue means. I think
It wasn't just sloppy.
No, I don't think it was inadvertence. I don't think it was excusable neglect. I think it was obstructionist. I think that they knew exactly what they were withholding. I think that they couched.
Yeah, I will tell you, I'm having a hard time there when they give you stuff 4 months before the arbitration hearing, and they specifically detail what they are and what they are not giving you, and that seems to me that you could have looked through there and said, hey, there is nothing here on this critical point.
Let me address that specifically, because I'm not sure I'm being clear. If you look at the objections that they made, the documents that they withheld would have been responsive to this, would have been included. I'm not doing a good job explaining that. The documents that they would have produced would have been included in the documents that they say they're producing. Does that make sense? So they make a qualified objection, and then they say, but we're producing these. The documents that Mr. Lynch testified that existed on the first day of the arbitration hearing would have been in that universe of documents, and they weren't produced. I mean, and I want to be clear on that. If there's a situation where, okay, you're saying you're not producing these because they're unrelated and they don't involve Chayce's work, I think there's still a affirmative obligation to produce those, and I think under certainly Arizona rules and under the AAA statute, which we cited in our rule that we cited in our brief, I think they're obligated to produce those. I don't think they have that's not discretionary. You don't get to determine, you don't have a right I'm sorry.
Finish your thought.
The issue in this case, Your Honors, is whether or not we're going to reward misconduct, intentional misconduct, or whether or not cases are going to be tried on their merits. That's what we're asking for. Thank you.
Thank you, counsel.
Thank you, Your Honors. I will be as brief as possible. I just want to clarify a couple points. Chayce is making factual arguments and relitigating arbitrator Friedlander's findings of fact of law. That's what happened here today. That's what happened in his briefs. That's what happened at the Superior Court. That's why the Superior Court's orders should be reversed. We have to rely on the record. And the record's clear. There's no record of a request for a postponement. The record's clear that these documents were produced, these discovery requests were 4 months prior. Although he says there's no mention in these discovery requests about documents being withheld, at at least one, I believe several, I don't have them in front of me, apologies, say that we are withholding documents on this basis and we will only produce certain documents. I want to make a point on undue means.
Before you get there, the documents that he's, it seems incensed about is the pay apps between your client and the city of Scottsdale.
Yes, Your Honor.
Why would you not produce those?
Your Honor, I was not the arbitration counsel.
Okay,
and
so you
so
don't know. But had they been produced, how would it have changed the outcome? Or do you believe it would have?
And we went in detail in our brief, Your Honor, is it would not have changed the outcome. And in fact, the arbitrator discussed these pay applications on several occasions and discussed why it would not have changed their findings.
And they weren't used at the actual documents were not used at the arbitration hearing.
No, Your Honor, they were not. And in fact, again, like you mentioned, they were held against Path Construction for not producing the certain documents, particularly as it relates to their damages claims. My last point here is although we're talking about postponement most of the time, Chayce did seek an application based on another part of the RUAA, which is undue means. Undue means requires intentional misconduct or bad faith in the procurement of the award. Also, this must be proven on a clear and convincing standard. Opposing counsel sat up here and tossed accusations which are completely unfounded and unsupported by the record at all. There is no finding of undue means, and it's certainly not under a clear and convincing standard. And I would mention that the Superior Court order doesn't focus their ruling on undue means anyways. It's based on postponement. So with that, Your Honors, I have 39 seconds, but I would be happy to address any other questions you may have.
All right, thank you. Thank you, counsel, for your arguments here today. We will take this matter under advisement and issue a written ruling in due course. We will take a brief recess to reset the courtroom.